webinar series that we host every few weeks. So I'm joined by my co-host, Advocate Kevin Malunga, and I'm just going to introduce him to everyone here quickly. So welcome, Advocate Kevin. He is our academic head of the Regenesis Law School. He's also served as the former Deputy Public Protector under the Honourable Thuli Madonsela, and has managed a governance and advisory firm that consults with various state organs on investigation, upskilling, conflicts of interest, corporate governance, and alternative dispute resolution. So a big welcome to my co-host, Advocate Kevin. It's lovely to have you join me today. My name is Alison Laxton. I'm the CEO of the School of Law and the legal officer for Regenesis. I'm also an attorney of the High Court, and we look forward to hosting our fantastic panel today. Now, we're just going to go ahead and introduce some of our panel members who are here with us. So I would like to introduce Advocate Jazz Vilakazi. Welcome, Advocate Jazz. Now, just to give you a little bit of insight around these fantastic legal professionals, Advocate Jazz has extensive experience in the high courts and in corporate law, labor law, commercial law, and family law. He's also served as the chairperson of the Student Judicial Services hearings at UJ. He's the chairperson of the EAAB disciplinary panel, and he lectures. So how fantastic that he shares this wealth of knowledge with students through lecturing at the Gauteng Society of Advocates, as well as at an institution known as Legally Law. Now, with more than 15 years of real corporate world experience in sales and marketing with blue chip and multinational companies in South Africa, we are honored to welcome him today. He's also served as a radio guest on legal matters. So let's give a warm welcome to you, Advocate Jazz Vilakazi. Thank you for joining us today.
Thank you for having me here, Ms. Lax.
Next up, we would like to introduce Advocate McGregor Kufa, and he joins us today. He has been in the legal fraternity for more than 17 years. He's been employed as a legal manager with expertise in corporate governance and has worked with a number of law firms in South Africa, holding various consultancy portfolios in areas such as cyber law, competition law, constitutional law, administrative law, and digital forensics. Very interesting. He's also authored and published multiple articles on cyber law, intellectual property law, and competition law. He's presented and lectured on corporate governance in various countries, including Namibia, Zimbabwe, and South Africa. His wealth of knowledge in cyber law, competition law, IP law, as well as commercial and corporate law, is one of the reasons we are honored to have him here with us today. So welcome, Advocate McGregor. We are delighted to have you on our panel. Thank you. Next up, we have Kundi Ramashia Dube. And she has recently taken up the position of a partner at Shabuse Attorneys. She holds a Bachelor of Commerce degree majoring in law from UJ and was admitted as an attorney in 2013. She's qualified as a divorce and family mediator and has extensive experience in family litigation, criminal and labor law practice. She was formerly employed by Hogan Lovells and gained experience in commercial litigation, labor law, family law, housing, and refugee work. So quite an extensive portfolio, but that's not all. She's also served at the legal office of probono.org, and she's also worked at the Office of the Family Advocate. Now, her culinary skills and passion for good food is also something that she loves to share with the world, and she has a food blog known as kundiskitchen.com. So, Kundi, welcome to our webinar series. We're very happy to have you back on board with us, a repeat panelist, and we're looking forward to the insight you'll bring today.
Hi, Alison. Thanks so much. Looking forward to it.
Next up, we have Advocate Corinne van der Linde, and she has been a member of the Johannesburg Society of Advocates since 2016. She holds a BA LLB from Stellenbosch University, as well as an advanced certificate in tax law with distinction from UNISA, an LLM in banking law from the University of Johannesburg, and an LLM in constitutional property law from UNISA. Prior to becoming an advocate, she practiced as an attorney, first completing her articles at Cliff Decker Hofmeyr in 2012, and then working at the Legal Resources Center, specializing in property law and the right to housing. She qualified as a conflict dynamics accredited commercial mediator in 2021. She's a general commercial litigator and mediator and has a particular experience and interest in banking law, company law, constitutional law, insurance, and insolvency law. So welcome, Advocate Corinne. It's a pleasure to have you on board with us today.
Thanks for having me, Alison. Thanks.
Next, we have Virash Rickerson, and she is the Director of the Fair Practice Dispute Resolution Services. She's also an ADR trainer or alternative dispute resolution trainer, a mediator, and a disciplinary chairperson. There is nothing that this lady cannot mediate on. So Virash, welcome. It's lovely to have a problem solver such as yourself in the room, and we're really looking to gaining some insight from you today.
Thank you for having me.
And last but not least, we are joined by Renilwe Maleka. She is the head of legal of the First Rand Group Treasury Services and has legal experience in leveraged acquisition finance, structured finance, syndicated and bilateral financing structures, debt capital markets, including securitization schemes, and transactions involving banking and financial institutions. So we are really excited to welcome all of our panelists here today and to explore our topic. And our topic of today is courts and legal practice in the digital age, thoughts from the modern lawyer. And we've seen an array of changes to how we used to do practice, how we used to attend court, how we engage with clients since the implementation of AI and the effects of COVID-19 and having to go online. So I'm going to pose my first question to the panel. And how has technology changed the legal industry, and what changes have you seen?
Oh, can I go, Alison?
Absolutely.
I can't even see whether my video is working.
We can see you.
Okay. Yes, this has been a very interesting period. I mean, especially occasioned by the COVID-19 pandemic. So I think the big issue is that people have to adapt to the changes in how we conduct meetings, how we conduct communication. For example, a few years ago, this very interaction would have been in a room with people sitting together, would have had to pay for flights for people. People would have had to drive in traffic, etc. So that has obviously all gone away. But obviously, the con of it is the fact that you obviously need very reliable internet, you need a reliable power supply, etc., which Eskom is not doing very well. I'm using an inverter right now as we speak. And of course, everybody has to dust up their technology skills and so forth. And we also need a very efficient state. I can't discuss this, Alison, without going into my past life. One of my old roles, which predates the public protector, is that I was, the chief of staff, acting chief of staff in the office of the Chief Justice, and a researcher when we started the office of the Chief Justice from scratch to try and make courts more independent, to try and make things such as electronic filing and other interventions like that more efficient. Little did we know that COVID-19 was coming and it would make that the normal way of doing things. So we also need an efficient state, an efficient public works. In other words, the procurement system by the government has to be efficient in terms of getting the right, the right supplier. Of course, currently that is the subject of an investigation as to how that was done. So it's not just Eskom; it's even going to this very contract that involves rolling out electronic filing and mediation in the whole country. So it means that people really need to, lawyers need to hold the government and everybody accountable and hold themselves accountable in this regard.
Recording in progress.
Very much, very much.
Thank you. And I think that is such an important point to make. Now I see, welcome Renilwe, thank you for joining us. I see we've got some videos on. So Karine, I'm not sure if you would like to add to perhaps some challenges that you've seen or even changes that you've seen in this new digital age.
Yeah, so I agree wholeheartedly with what Kevin mentioned, that the COVID-19 has certainly catapulted us into a digital age of litigation. I can obviously only speak from a purely litigation advocate's practice, but what that allowed us to do is a lot of us could carry on working through the digital, through COVID, when I don't even think the other provinces were as fortunate and as advanced as we were in Gauteng with our court online and case lines. So that certainly has been a big benefit. But challenges also, and I think Kevin was touching on that, is you need things to function well. One difficulty that we faced as advocates, that I can at least speak for myself and perhaps some of my colleagues, is effective and reliable Wi-Fi in the courts themselves. In order to, the one needs to work with the other. There's all the benefits of having cloud storage, having all our documents online. There's no longer an issue, and that was an issue with me when I was doing my articles 10, 11 years ago, is court files would get lost. We no longer have that as an issue, which is wonderful. But then we need, obviously, the infrastructure to function around us to carry us through this digital age. Thanks.
Thank you, Advocate Karine. I think that's some fantastic points made there, that the technology has been both a blessing in some respects and a curse in others. Virash, I see your video is on, so I'm not sure if you'd like to contribute.
Thank you, Alison. I was following on what Kevin has said about mediation and that forming part of the digital age. So with mediation and with the pandemic, a lot of disputes came to us mediators online because we were available. People could mediate from their homes, and we could carry on with access to justice online through mediation, which is a dispute resolution process as well, which is recognized by the courts and recognized in our rules. So we could continue with dispute resolution being effective, getting outcomes, at least moving towards settlement, or at least narrowing down issues using the mediation process between the disputes. And so you're not sitting and wasting time or waiting for a court date, which we never knew at that point when that was going to be. We already know we have an overloaded system that's got backlog. People wait over a year for a trial date. Mediation stepped in, and online people could meet, people could discuss, people could begin negotiations. There could be transfer of information online. Access to information was at the tip of everyone's fingers. At that point, everybody knew Zoom went from unknown to very well used. So we could use Zoom. We used it effectively. I think I'll discuss that more on online dispute resolution forums. And what happened there is we could put more information as we were mediating. So it was real time information. We used the technology, and the communication was instant. It gave us advanced. It progressed in an advanced way. The learning curve was very quick, and so everyone had to jump on board and learn as we were doing it, making mistakes, getting lost in the internet. We learned, and now we've adapted to it.
Thank you so much. And I think that that's an incredibly important point is we didn't know about MS Teams or Zoom or all of these wonderful things before COVID. And this sort of brings me to my next question is, how did you have to update your various practices? How did you have to train your staff? And what sort of challenges did you find in rolling that out? There were many practitioners who called for case lines training to be done and training on Court Online. And perhaps if my colleagues and panelists here would like to give me some insight as to how your own practices had to keep up with all the changes that were happening post-COVID and in this new digital age of litigation.
Yes, Mr. Laxton. I was lucky enough, in fact, on the first day of our lockdown, 27 March was it, 2020, to have been on the road that day, and I had to get to court because we had an urgent application. And so whilst we were in court, we were actually running a virtual hearing inside Johannesburg High Court. And a few months prior to that, I've been trained in terms of case lines, and I can tell you that case lines has been a game changer for us as younger practitioners. The older practitioners have taken time to get around to it. But for instance, I think one of my colleagues mentioned that court files were getting lost, and case lines doesn't keep working hours. It's open 24/7. It also keeps track in terms of documentation that is there, and it has also removed then the need for physical service to a point. And how then I have managed to keep up with this is that I've used case lines, my attorneys have used Court Online as the go-to place. Once the document is there, you can effectively then get all of your pleadings from there. When one has had to be pressed for time, for instance, and you need to prepare heads of arguments or responding papers of some kind, because case lines is never closed, you could now effectively go and upload papers at 5 p.m., 6 p.m., close to midnight. And the beauty of it is that it's accessed anywhere worldwide. I had the pleasure of being overseas, and I was still being able to keep in touch with what was happening on case lines because of the ease of getting in emails being sent to notify you that there had been a change on it. The second thing that I think is important for us in terms of keeping up with modern changes is just the impact of AI in particular and the internet in general. If you ask any of my colleagues, they'll tell you that there was a time when we literally had to sit down, grab a book, grab a coffee, and just read. And even that reading was preceded by quite a lot of legwork in terms of narrowing down the scope of what you had to find. The internet and AI has completely changed that. And now with a few clicks, a few buttons, you are able to zoom in effectively to what you need. So lawyers being up to scratch in terms of internet usage, being up to scratch with things like SAPLI, which is so important for the majority of lawyers because the biggest thing that we argue here is case law. Thank you.
Thank you, Advocate Jazz. And I think you've made some really important points about how legal research is changing. There are going to be law students who will never need to pick up a law report, a physical law report. And just the thought of that is mind-blowing, that there are students out there who've got access to wonderful online platforms, and that even practicing attorneys and advocates themselves with platforms like Case Lines and Court Online can be on the beach and checking their cases. And that's something none of us would have ever imagined possible. Advocate Karine, I see your video is on.
Yes, I just wanted to add to my colleague, and I agree with the sentiments of what he said. Another thing, and I'm just now speaking to also to an advocate's practice, which I think was quite a big change for us, is actually the skill of advocacy on an online platform. It's quite different to standing on your feet and arguing in court, and that was actually a skill that we had to. As advocates, at least, learn how to argue on a. It's not as simple as just having a video call. It's also to have the sort of the nuances of that advocacy skill. That when we were training, we were taught to present standing on your feet and arguing to a bigger courtroom, and that's also another skill that I had to personally learn that, which is quite a bit different. So I just wanted to add on to that.
Yes, and I think that that's an important point, is when you are in court physically witnessing court proceedings and you have to go and argue your case before a judge, you have a certain presence, a physical presence. And when you are on an online platform, that can fall away very quickly. And if you don't know how to present yourself online, you're speaking to a screen, but actually there are people on the other end. It's quite a nuanced and important skill. And I'm sure that various other people have seen the difference with this as well, in that when you consult with clients, for example, that was also done in person. Now it's done online. And that human aspect has somewhat fallen away, which makes it a lot more difficult sometimes to be convincing in your arguments, to be clear, to be coherent, and to be, up to date with using the platform. If you are fumbling around and you're presenting your argument for a judge and you can't get your video on, it doesn't create a good impression. And things like that are really important to actually upskill our advocates and attorneys who do appearances on. So thank you, Karine. I just now want to bring another point there into AI, and Advocate Jazz has mentioned this, and AI has been the new buzzword, and then ChatGPT made landfall, and people just couldn't believe this wonderful AI platform. Now, Doravis recently released an article, and I wonder if those of you have seen it, where they compared a ChatGPT answer to the answer of somebody who was actually a senior legal practitioner. So, do you think that AI is something that is going to help us as legal practitioners, or do you think that it's going to be something that will harm us as legal practitioners? And there's been a lot of talk about paralegals possibly being replaced, losing that sense of critical thinking. Louis Case Law recently posted on why he doesn't want to use AI, why it's important to keep that critical thinking. So what are your sort of thoughts about what AI is going to do to the legal industry? And I see Advocate McGregor, you've got your video on. So we're struggling to hear you there. Sorry about that. It may just be your sound. While we get Advocate McGregor back on, would anybody else like to contribute?
Perhaps I can just quickly jump in whilst we wait for my colleague. Ms. Laxman, consider this, because this goes to the impact of AI. Consider the child who gets a poor education but wants to be a lawyer. Now, not only do they have the impediment of their education, but they also have the impediment of clearly articulating themselves because they've not been exposed to that. So what does AI now do? AI now effectively bridges this gap in one's decorum, in one's delivery. AI is now at a stage where they can give you 1,000-word speech that you can effectively get to court and read out. And what I see is that the positives far outweigh the negatives when it comes to AI. After all, we have had AI in the form of Google as well as the internet in general. It is now simply one massive platform that takes your thoughts, as it were, or your questions and puts them together and gives them to you in a presentable form. Now, what are the issues then that we are going to face with AI? Now, the newer professionals, you mentioned kids in university currently doing their LLB, they'll never effectively get to know the nuances of argument, listening to your opponent, jotting down those points, the ability to think on your feet. I mean, it is probably close to damaging to the soul to have a judge ask you questions you're not prepared for. But as a lawyer, you need to stand there and be able to think on your feet, come up with case law, and be able to answer that. The other problem, though, with AI is that it's going to manifest what I call the shortcut syndrome. Because at the end of the day, as a lawyer, my colleagues will probably confirm, it's our duty to collate as many sources of information in order for us to make our submission. Now, AI is perhaps giving you 4 cases, well summarized, and that's it. But what happens to somebody like Louis Caselaw, who has been in the field for 20 years and can therefore bring up a constitutional case that fights off your point? And then the last issue that I see with AI is what we call Google agreements. Now, I was in a case where a father wanted to contract out of the rights to raise his own child, and he got an agreement of Google. And I mean, the court literally almost laughed at us because you can't contract out, but AI will somehow leave you believing that you can contract out of those things. And those for me are the issues. I think the last one, which is the bread and butter of all lawyers, is drafting. I think that's where we make most of our income. It's where we prepare ourselves well. And AI is going to upend drafting to no end. And we need to be careful of that. There's probably no way to overcome it, but it's to take that and make it a friend. AI and
Thank you, Advocate Jazz. So some really important points there. Renilwe, I see you've got your video on. I'm not sure if you'd like to contribute. Welcome. It's lovely to have you on board.
Thank you so much. It's actually funny, as life would have it, that we're having a discussion on technology, and technology failed me a little bit. But I hope you can hear me. My company policy actually doesn't allow for Zoom, but if there are any glitches, you let me know. So I come from a little bit of a different, end of profession than my esteemed colleagues on the call, in that I'm not in legal practice at the moment. I was actually when COVID started. So I do agree quite a bit with what my colleague said, but I am also not in the court system. But I'm just putting on my video based on what Mr. Villigazi just said now, just to agree that even in my profession, so I'm at a bank and obviously largely commercial. And even though the human element is largely not necessarily there, and especially when it comes to things like banking and finance, we have the Loan Markets Association, which has generally standardized agreements. There are certain things that are quite market standard, and the place in which you move or you negotiate isn't as much. So in essence, I think if someone was looking, if I was the business guy here and I'm like, well, I can get ChatGPT instead of getting 4 lawyers, I'd actually do it. It may make sense. It might be a quicker turnaround, and in any event, most of the things are boilerplate. But I do agree that it removes the human element, not only in the drafting, because in as much as a lot of things are market standard has been created through obviously years and years of negotiating certain things. And speaking as a transacting lawyers, it does remove the element of negotiation. I think, obviously, as an in-house lawyer, but also working quite closely to people, and funny enough, the idea or the discussion around AI was discussed with some of the commercial teams here. Thinking of a bank and thinking of things like calculations, having to calculate rates and that kind of thing, even they were concerned that, just like Mr. Villigazi said, it would be the same as looking at Google, or the same as looking at the validity of Twitter or social media or any of these other AI instruments, that one, you need to get to the process of verifying. But if you're putting the legal element of it, where you're saying, based on certain qualifications and certain conditions, or taking into account certain things, my opinion is that this is what it is. I think if you I don't know to what extent, if I, for example, am saying, okay, well, I've let go of 2-3 of the legal advisors, and I'm going to use this AI. I cannot say for sure to what extent I can trust that kind of source. And I think that's just the element that comes in, the human element, the negotiation part. But even when it comes to things like opinion work, yes, obviously they would be able to provide for, the different sources that are there. But I think it does create, although the problem would be, as was said, the positives are there, the work is there, automation is there. But I think the main element, which is to have that human element check and the negotiation part, would not necessarily be there. So I think that's I think the problem that I would have regarding the AI. And I think I was just also raising my hand when I finally got to the chance to sort of switch this on, to say, from my side, when you think about things like execution, things that had to advance quite a lot had to be our thinking around signatures. It seems like a small thing, but for the longest time, the Electronic Communications Act has been there to say, well, if an agreement is there, and for an agreement to be valid, it needs the following things: identity of the person who's signing, and all of those elements. But over and over again, and being someone who's working at a bank where there are global firms that do not necessarily want to use certain electronic instruments versus others, there's been a move for all these electronic companies to sort of get more aligned with ACTA and get more aligned, because the idea of having to have wet ink signature, and there are a lot of global firms that are still pushing for wet ink to say, well, in our country, or we don't know if we trust the electronic signature or digital signature processes for South Africa. You guys need to sort of upgrade this kind of thing. So I think when it comes to those kind of things, it has moved quite a bit. And I think from my side, just thinking of what I can add, because I'm not in practice or in the court system, that's definitely been one of the things. So it's something that I think we've also seen some of the law firms have helped with. There's been a move more to work, for example, with Law Trust, DocuSign, Diligent, that kind of thing. So I think that also adds to your question just before on the kind of training that needs to be there to ensure that we can be able to do our job, as the lawyers here, and make sure that things like execution are done properly. So sorry, Ms. Laxton, that was just...
No, that was brilliant. Thank you so much. I think, and it's so great here, we've got such a diverse panel, right? Because we've got people like myself who sit in a more academic role, and with Advocate Kevin, and yes, we are exposed to practice, but we're certainly not on the front lines like our advocates here. And then we've got people like yourself, Ranilwe, and Viraj, who are in other specialized sectors of legal advisory. And I think that there is so much opportunity as well. And we've always stated that a lawyer's time is his money. Unfortunately, you can only bill for as many things as you can draft in a day for a lot of attorneys. So there may be that way to find that balance. So Advocate McGregor, I'm not sure if your sound is working now. We're going to give it another try.
Can you hear me now?
We can hear you. We'd love to get some of your input. Over to you.
Yeah. Okay. Thank you. I just wanted to give an input that we are ending up being like the jutting rock in the torrent of the advancement in cyber forensics and cyber law and the introduction of artificial intelligence. I remember when I first came across the mooting of artificial intelligence, that was in 2008, when there was a law firm that I was a consultant for when we were trying to use artificial, at that time we were not calling it artificial intelligence, it was a term that we were using for it to assist in trying to get to capture case law and also to capture information. But there are risks involved with artificial intelligence. That isn't artificial intelligence going to replace us as lawyers? Because at the end of the day, artificial intelligence might even end up locking us out of the system itself. That's my fear, because with artificial intelligence, there's a lot that can be done. We have heard the previous speakers about talking about how you can do your research and have your case law done by artificial intelligence, have your pleadings drafted through artificial intelligence, and having your case now presented in court through artificial intelligence. And with the way artificial intelligence can also now mimic my voice, I can end up having my voice being mimicked. I can actually appear in court and put on my video and say I'm about to speak or address the court. And then when I mute my video, I then go to AI, which will then present the case for me because it will have mimicked my voice. Is that where we want to go to? And I would like to say absolutely not. We need to have some way of supervising artificial intelligence in such a way that it doesn't replace the human element. Thank you.
Thank you, Advocate McGregor. And that's some, important things to remember. Those are important things to remember. Is that there have been, what they call a deep fake, and it is somebody's face photoshopped, and it's all AI, and it looks very real. And we have to make sure that we police the extent to which AI can assist us and be helpful. And we've also seen, with the use of ChatGPT, that if you do try and run certain things through it, it can be heavily critiqued. And Durevis has also done that article, which is quite a fascinating read, where they compare, the difference between a seasoned legal professional and AI's mimicking of that. So this sort of brings me to another question I'd like to pose to the panel. And do you think that there are any ethical considerations or things that we should think about when using these digital platforms, perhaps AI systems in legal practice?
Thank you, Alison. Just a quick one on that. Like I said earlier on, there needs to be supervision of how artificial intelligence is used. We need to, in other words, police how artificial intelligence is going to be used, because at the end of the day, there's going to be a plagiarization of ideas where people will end up using certain information and without acknowledging the sources. And then at the end of the day, we're going to also have the courts functioning in such a way that judges might end up relying on artificial intelligence, which might actually change our course of lives. And that brings an ethical dilemma that whilst it is encouraged, but there needs to be some form of regulation for AI in that regard.
Thank you, Advocate McGregor. I fully agree, is that there is that need to regulate. Virash, I see you've got your video on.
Thank you. Well, I did practice as an advocate, and I understand that ethics is part of being a competent professional. When I moved into mediation, ethics is what we rely on because it's an unregulated profession, as focusing on competency and focusing on giving clients that efficient process. So in the mediation, what is very key is confidentiality. And you have, when using technology, you have to manage the confidentiality of receiving files, receiving information in itself, sitting with the disputants or the participants, managing that confidentiality of not recording, if you're online, not secretly recording or having someone in the room recording what is going on. So those are some of the ethics that you have to manage from an online dispute resolution point of view. And then, of course, there's the bias. You have to manage that AI is not operating on bias based on past performances, based on data. So as lawyers, we have to be able to track any information that an AI sends out, that it does not do it based on its own biases created through previous practices or discrimination that currently exists amongst a certain group of people. And one of the other things about access to justice is using technology. We cannot discriminate against low income or underserved clients. We have to be able to use technology to open the doors for everyone to have access and fairness of the process.
Thank you so much, Virash. And perhaps something I can ask you, just to clarify, because you've got such an interesting mediation practice that you run, is, I find that, and we call them keyboard warriors, people who are on Facebook and they're very aggressive and they're very passionate, and then you meet them in person and actually very non-confrontational. So has technology and mediating over a virtual platform, has it affected how you mediate? Has it affected certain techniques? What sort of observations have you made as to, is it effective or not?
Is mediation effective online?
Yeah, I think through virtual platforms, how do we run with those? And have you seen any big differences since having to go online?
Oh, yes. So you have your keyboard warriors, and what they look like online are cyber bullies. And when you meet them in person, like you said, they're quite meek, quite reserved, calculated, intelligent compared to anything they've posted online. As a mediator, you refrain from getting to understand or getting to know your clients other than their profession, information about them. Be careful about going down the rabbit hole of formulating an opinion of your disputants or your participants, because that in effect will affect your neutrality and impartiality. So there is drawing a line of getting to understand. And again, and I talk about unconscious bias a lot in my presentations and webinars, about how when you go down that hole of trying to understand the personality of the disputants, you start becoming biased towards them before you even meet them. So when they do present themselves to you in a mediation, whether it's online or in person, and you've gone down the social media route of trying to understand who they are, what they look like, and they're completely different, your mind has already created a bias towards them. So having access to social media in terms of who your clients are, who your participants are, is a dangerous tool to have. So instead, focus on understanding the person that you're dealing with, the person that's coming there, their social standing, what could possibly affect their status, their affinity, who are they related to, not understanding their type of character. Like you said, they could present as one person online, but when you actually meet them, they're a whole other person. So it is very important to not let your understanding of their character affect the dispute resolution process and your behavior as a mediator.
Thank you. I think that gives us some really great insight. And we don't realize it, but unconscious bias, and like you've said, through looking at somebody's social media, it's very prevalent, and you may meet them and think, well, I made up all these things in my head about who they are. And we've really changed the way in which we've interacted with clients. And a lot of attorneys have received referrals through Facebook groups, through LinkedIn pages. It's no longer going through the old hard cover books to find a correspondent or an attorney in your area. And I think that this has also really changed how we source and engage with clients. There's been very much a blur or a distinction between what a social media platform can be used for. And we've seen various law firms who have wildly popular Instagram pages or Facebook pages or Twitter accounts. So this is also something quite interesting. And I'm not sure if anyone here on the panel wants to maybe talk about how they're engaging with clients. There are even WhatsApp features, on websites now that allow you to speak with companies and assistants through WhatsApp. So if anybody here has some insight into maybe how they've changed in engaging with clients, then we'd love to hear that as well.
If I may, I see no one else has volunteered as yet. If I may, we do use our website, and if anyone goes to the Fair Practice website, they can see that it's quite interactive. It gives a lot of information. And I think that's where legal professionals, if you're watching and if you're listening and taking notes, having an online presence is so important for you to let clients know how competent you are, how knowledgeable you are, that you are an expert in your field. So even investing in a website, investing on social media platforms, use it competently and use it diligently, but use it responsibly. Your persona and your brand must match on all social media platforms, and that's what we capitalize on. And it has been noticed how we are known globally as Fair Practice and Media Dispute Resolution Services, because our brand stays on point. And when I lecture to upcoming legal professionals and to mediators when I'm training them, one of the topics we talk about is what next? We now have qualified. What next? How do we get our clients? Well, you are your brand, and they focus on what you say. So anything you post, be responsible about it. And there's a lot of WhatsApp groups currently that legal professionals are using to collaborate on, to exchange information on. It's not an advisory service, although some people, for instance, attorneys can capitalize on asking questions if they're getting lost in process and information. So yes, using social media has its advantages, but use it responsibly. And remember, you have a brand and reputation to protect.
Yes, absolutely. And I think that, in this digital age, we've actually become, more exposed to the public's perception of us. And there have been various accounts of people who are held in high standing then going to Twitter and posting something, or going to Facebook and having a rant about an issue, and it ultimately becomes a trial by media. So very important to remember as a modern lawyer or legal practitioner that your social media presence is important and you are your brand. Now, I'm going to hand over to Advocate Kevin Malunga. I'm not sure if you would like to pose further questions to the panel.
Okay, let me unmute and mic. So, I think for me, the elephant in the room really is how, first and foremost, to the panelists, what advice do they want to give to people, practicing in the digital age, from their own experience, from a personal experience? That's the first question that I want to pose, to say, look, what is it that you feel can be done better? What can be, how can we make this work?
Thank you, Kevin.
Thanks, McGregor.
In order for it to work, practicing in this digital age, I'm all for embracing the use of the internet for almost a host of things that you can do pertaining to your practice. But I think there's a way also of ensuring that there's consistency and also parity in ensuring that, for instance, if you are advocates, there's a certain, if you are going to use artificial intelligence, there needs to be a certain artificial intelligence tool that needs to be properly licensed, that needs to be accountable to the system, so that we need to have accountability. Equally, also for students who want to use artificial intelligence, there need to be certain tools that can be available for students, but those tools need to be licensed. So we need to have a regulatory framework, like the kind of regulatory framework we have through ICASA for your mobile network providers, how they are regularized and regulated. Equally the same we need to have for artificial intelligence tools, so that the digital age will not be compromised by artificial intelligence that might be of some sort of ransomware type of artificial intelligence that will end up locking us out of systems, demanding ransom for us to be able to get access. So we need to be quite coy about that, and we need to be very circumspect of.
Yes, and part of the point is the ethical considerations. I mean, they've been discussed. How do we navigate that space, McGregor, in terms of?
Yeah, like I said, the ethical considerations is that we need to have a sort of a charter on how do we use artificial intelligence. How do we, because remember we are having a lot of NFTs, your non-fungible tokens that people can make money from. You have cryptocurrencies, a whole lot of digital transactions that are going by that one doesn't even need to leave the comfort of your home or your office or your chambers to be able to transact. So we need to be able to have a way of regulating those processes. So that's why we need, like for instance, at the Reserve Bank, we need, as a matter of to have a regulatory person by a certain desk being ascribed to the Reserve Bank to be able to assist in analyzing any digital transactions being done to ensure that there's a framework for regulating those. Similarly, for lawyers at the LPC that have a dedicated desk that also going to regulate those processes. Because if we don't, there's going to be an ethical dilemma.
Yes, and I think as Ms. Laxton posed earlier on, there's a lot of faking currently as a result of. So I get a sense that there are going to be a lot of fake lawyers in this current era. I mean, I don't know if people have been following the Thabo Bester issue. That's the allegation, the media allegations, that he was posing as an advocate in the past few months as well, among other things. So, but I think, I don't know if there are any other takers in this regard.
Hi, I just wanted to also mention, I agree with the view that as the legal fraternity, we need to embrace it. And we need to embrace it, obviously, within reason, and we need to embrace it responsibly. So as practitioners, our ethical obligations must still obviously remain, and perhaps it must be heightened, particularly in regards to issues such as obviously plagiarism, which may also become an issue on the tertiary level. Another thing, and I think just to add on the question that was posed to the group, the advice that I would give to practitioners in this age is education. We need to educate ourselves to use these tools properly. There needs to be a proper education on court online, on case online, on how Microsoft Teams work, how Zoom works, all those various areas. Because when the legal practitioners, if we had to talk now 30 years back, they had no such thing as us working on computers as we do now, and look at how far we've come from that. So I think we need to embrace it and move along with it, because it is so important for the development of the profession, and it makes the world a bit smaller in the sense that we can litigate across jurisdictions, do international arbitrations, etc. But it does need, along with it, as Advocate McGregor said, there needs to be proper regulation in place.
So, and Karien, maybe if I can just put you on the spot there as a follow-up. Do you think that we as lawyers are going to survive this whole era in terms of that we're not dispensable? So, for example, I'll give you examples of situations where some people have been, dispensable. For example, banks. If you take many people. When was the last time they actually walked into a branch? So you find that a lot of bankers, and a lot of, my own. I'll say it. I bank with one of the banks that I bank with. They closed a lot of branches, right? Because now people are just using the cell phone banking and internet banking. Same with travel agents. You can book your flight on your cell phone and book your hotel and etc. So my question is, will we one day find ourselves, because this is a digital age, are we going to be replaced by apps as well? Someone have a lawyer app?
So I think it's a very crucial question. My personal view is that you cannot replace a lawyer or a judge, and one of the simple reasons I think this is because there is that subjective element that you can't ever contract out into an AI platform. I certainly think that things have changed and we're going to need to navigate that. For example, sort of research tools and AI sort of going into that space of taking over perhaps legal research. But you will never be able to, and I think this also speaks to a mediator chatting to my colleague, that no AI will be able to fulfill that role. I'm trying to think of some examples. You know, our legal system, our common law is based on case law. Now, those judgments are written by judges who have all added their subjective element to it. Our interpretation of the judgments differ. Our courts need to interpret judgments, and that's how we end up developing the law. And I don't think that AI can take that over and develop our law. Although I do think there are other aspects, as I've mentioned before, where AI is going to take a lot more inroads into the legal profession. I think one of them is drafting, like my other colleague said. But even when you talk about M&A lawyers who structure big deals, their agreements are colored by their subjective experience. So they think, well, we ran a deal on this contract before and it fell apart because of A, B, and C. And that is just a subjective human background that they've added to that deal. And I don't think AI can take over that role, at least. Thanks.
Kevin, yes. If you don't mind.
Thanks. Yeah, thanks, guys. You can go for it.
Good.
I think one of your other questions was around, you know, what do we give the new guys or the new practitioners coming into the field? And I still think that the age-old advices are still imperative. Presentation, coherency in argument, respect in the court, and our summit for each lawyer is prepare. Those ones are quite important. But insofar as whether we are going to get replaced, well, I kind of hold two parts to it. The first one is it's pretty difficult to come up with an artificial brain, you know. But what AI does give us, what the internet gives us, is a new angle of having a response much quicker. I was involved in a dispute in terms of customary marriage where I was for the lady and she was saying there was a marriage act. The husband was saying there was no marriage. And my one colleague was referring to an act from 1927. But the beauty of that entire exchange is that I had the availability of a laptop with me. I was in court, but I wasn't physically in court. And because I kind of keep all these acts in a folder, I managed to go to the act as he was talking about it. And I picked up, no, man, this thing has been repealed. And then I picked up specific sections. So I was able to come back with a response to the judge. That thing I spoke about earlier of thinking on your feet. So AI in particular, and the internet in general, does give us now a compressed or a shorter period of time, rather, in which we can look for answers and come up with answers to what.
And maybe if I can just put you on the spot there. You know, one of my friends, you know, he's just left. He used to be the vice chancellor of the University of Johannesburg.
Yes.
His passion is this, Marwala, his passion is on this AI for the fifth industrial revolution.
Yes.
And one of the findings that they had was that AI or GPS, all these new things that online, they tend to be Eurocentric or Western-centric.
Yes.
So would you get a sense that, let's say you're looking for Vilakazi, you're looking for an African solution, like you mentioned in customary law.
Yes.
Do you get a sense that the net is adequately covers African conditions? Because I think those are the kind of things that often come up. That sometimes, like when you put in your GPS, sometimes a destination somewhere in Mutru or wherever.
Yes.
Sometimes it will take you to. There's still a problem there. You get my point?
Yeah, I do.
So
Yeah.
now we move that to law and say,
Yes.
well, is that still a relevant problem? Because the scientists have identified that to be a problem when it comes to other things.
Yeah. So I think in response is, and especially let's use customary law as an example, probably the most underdeveloped or infancy stage part of law, as it were. And this not only speaks to AI, but it, for instance, speaks to our judges. Remember, we all walk into court as legal professionals, or we argue wherever we may be, with our own prejudices. And those tend to come out sometimes within the papers. But what we are finding is there is now more proliferation or information reaching the internet insofar as something like customary law is concerned. And it is pushed, luckily for us as professionals, by academics. It's also pushed by a lot of the disputes, for instance, the issue now around King of the Zulus, Misu Zulu, and as to whether he now is the rightful heir to that throne. Now, with judges in one side, with professionals such as professors and people that specialize in that field, that will give us a growing body of work. And so what I've found in terms of AI in particular, but actually the internet in general, is that there is a bigger scope for you to be able to read. I must also add that AI and the internet are probably not yet at a stage where they can replace the textbook, which is researched properly, etc. The other part I wanted to touch on is whether we are going to be replaced. I think that's a great question. So I'm not sure if you're aware that AI in America has been sued for practicing without a legal license. In other words, they're not registered. And I think with us, I mean, everywhere in the world, for those countries which are pretty advanced when it comes to their legal standing, there is regularization by the LPC, and all of us are registered. So I think we won't necessarily be replaced that way, but we will be, I feel, replaced when it comes to the paper pushing aspect of law, which is roughly the 75%. And this, we've already seen this happen. We've seen it in medicine. Do you realize that Google accounts for more results in terms of self-medication when it comes to a pandemic like COVID, for instance? People turn to Google rather than to real doctors.
Oh, yes,
So yes, from that aspect, we will be replaced. And perhaps it's going to be like a chess game after all. You can play chess against the computer, isn't it? And the computer can beat you. But ultimately, humans still show that they can defeat a computer that has got an infinite number of moves. Thanks, Ken.
No, that's a very interesting one, Jazz. It's. I think one thing that obviously comes up there is the fact that you mentioned the LPC, and I think there's going to have to be a lot of vigilance on their part in scrutinizing who is a genuine and authentic lawyer and not, because online everyone can claim anything, and someone can call themselves Jazz Vilakazi, put their picture up and practice as you. So those are interesting dynamics. Is there any other input on this particular question?
Advocate Kevin, if I may, we also have a question from one of our live attendees on LinkedIn. Lindley McKenzie has asked a question. So Lindley McKenzie says here, digital channels bring great experience, but what happens when you are traveling abroad and have to attend court remotely? What are the international challenges with working remotely from any country? And perhaps our colleagues who attend court remotely would like to answer Lindley's question there.
That's a good one.
If I can just volunteer, or perhaps stimulate Kevin go first. Thank you. Oh, sorry.
No, I'm fine.
No,
I'm fine.
I heard a lady's voice, so the lady ought to go first, if I'm not mistaken.
As far as I know, there aren't any limitations. If you have your court robes with you and you're properly robed and you've got an internet connection, you can dial into the Microsoft Teams platform. That's what we use currently for our virtual hearings. So as long as you're there on time, virtually speaking, and you've got your appropriate attire and an internet connection and your laptop with you, then you are able to attend that hearing.
Thank you, Advocate Karine. Advocate Jazz, I'm going to hand back to you now.
Yeah, thank you. 100% Advocate Karine is correct. I was lucky enough to be on a bullet train in Switzerland, whilst actually being able to attend to a matter that involved mediation in South Africa. Whilst it's not strictly court, it's along it falls within that understanding that we have, because these things can move on to courts. So if you've got your robes, if you've got your bib, you should be fine. I've also, sat in Cape Town and attended hearings in Johannesburg. I attended a matter in Cape Town High Court, but sitting up in chambers in Johannesburg for a client that lived in Hermanus. So this is the beauty that has really been spearheaded or hastened rather by COVID-19. And now AI is already now adding its tentacles to that. It's going to be pretty easy, and perhaps lawyers will now start taking more holidays.
Thank you, Advocate Jazz. And isn't that a wonderful thought that you can be on a beach? Renilwe, your video is on.
Yes, sure. So I just wanted to speak to the question of whether we'll be replaced, and I guess any advice. I think, in as much as I largely agree that I don't think us being replaced, it might not be in this lifetime. And I think that, you almost always need the human element. But I don't think we must underestimate the level at which AI can progress, because what AI was 2 years ago is different now. And as much as we can, I would speak to a point that was raised on M&A, and it's a point I raised in terms of the negotiation part, that, well, they can have the boilerplate clauses, they can have the drafting, but what happens if we need to negotiate? I don't think it's above scientists and people who can, advance knowledge to say, well, we have these 5 cases before, and this is what we've done. So I think, and thinking about the fact that we live in a capitalist world, I think, AI can go quite far. So I'm in large agreement that we must embrace it, but I think we must not take lightly the part to regulate it, because AI is not anything outside of the AI user. So that's what actually where the threat is. So once the AI user there, and we say, well, to a certain extent, we must still keep on sort of, regularizing this. I think that's where it would help us, but I don't think we can do that without educating ourselves. So the point that was raised on educating ourselves, I think it was quite important. And as much as you're a lawyer that has to do, bookkeeping, tax, all these things that in one way or the other impact your area, I think technology is a big one. I would say for almost every profession, knowing where the 4th industrial revolution is headed and how quickly AI is advancing, I think we need to know, in order to get the solutions, and in order to know, you mentioned Microsoft Teams. A lot of us use it for calls, but there's so many more things that are done there, and if we worry about things like confidentiality, for example, it was raised on the mediation issue. There's no way to stop someone from recording. But if in the regularization we say, well, the Microsoft Teams must have some kind of thing that can detect, we don't know how far technology goes, that they can detect if another device is recording, that's where you protect ourselves. So I think we need to be involved in terms of how this develops. We're not people who are, we're not technology people, but I think we mustn't just so, and that goes for our profession, but also people in the social sciences, because the only way we can lobby for change is if we're involved in it. So I think we need to be involved when it comes to things like legalization.
Thank you, Renilwe. That's a very important thing you've mentioned there. And I see, Viraj, your video is also on. So if we can maybe also just give you the opportunity to speak as well.
Thank you. Renilwe's passion of saying we're not going to be replaced just sparked something in me. It's true in the sense, especially when she's coming from the negotiation point of view, because that's what we effectively do in mediation and in as settlement counsel, for me as a negotiator, because we have to manage as human beings, firstly, the power imbalance in the dispute. And AI is not going to be able to understand that. We also have to manage the emotions. I see a lot of it. And one of the things people come to us for is because they want to trust us. I don't know if they can trust AI just yet. I mean, is AI actually going to be their support animal? Is it actually, what type of support is AI going to give them from an emotional point of view, building rapport, creating a trust relationship, and developing mutually agreeable solutions from a negotiation point of view? And I see a lot of from the negotiation part of it in terms of disputes. Most of the disputes that come to me are to be negotiated, to be settled, and they want to talk to each other across the table directly, not having someone, not even a mediator, interject in those negotiations and strategies. So human beings develop the legal strategies. We develop the strategy on what we have to do in that dispute.
Thank you so much. Advocate Kevin, back to you.
Yes, I think thanks a lot to the wonderful insights. There's something that's been bothering me in terms of the discussion at the beginning when people mentioned that when this whole thing started during the COVID pandemic, they had a problem with e-filing, right? There were glitches. The courts had internet problems, etc. And of course, you've all seen the story, big story in the newspaper, that the allegation that the tender was rigged for that involved Thomson Reuters. So for me, the question then is, are people finding the system to be very efficient? Because I'm raising this because obviously, even after this session is over, some decision makers will watch this. They will watch the recording, and they must know that if they're messing up, they're messing up. You know. So that's important for me, given my own career background. That those kind of things mean a lot to me. So the question for me is things like e-filing, the technical stuff, the appearing. Obviously, load shedding is a big issue. You have a judge falling off the screen and stuff like that. But what I want to get a sense from people whether the technology is up to standard. Do they feel that it can be optimized, and so forth? I mean, there are international benchmarks and things like that to look at. But it's just a thought that's been nagging me, especially since people mentioned that they've had problems, especially at the beginning. I don't know if someone wants to respond to say, look, is this efficient? Is the proper training? Are court officials on top of this?
Yeah. Kevin, thanks for that. My experience is we had a lot of teething problems, standard for any migration that a court has to have. Court officials, where people were just chasing their tails, basically. Go to case lines, upload it there, and then Court Online comes on board, and that's closed at certain times of the day. Court Online specific. And then sometimes you show up in court, get your paperwork stamped, given a case number, then you've got to go and upload the case lines. But for by and large, as things currently stand, and I say this because I've got a lot of senior counsel within my bar who have now taken onto case lines and find that it is such a great tool ultimately. Because, consider driving to Johannesburg just to go and do a bit of paperwork, and you're arriving there at 10 o'clock.
And getting mugged.
Well, I was going to say that. But all the nightmares of being in the vicinity of the court, etc. I do think that there's probably space for improvement, especially when it comes to the aspect of removal of documents, which is something that I am picking up now. if you and I are litigating and I'm not happy about a specific document that was put on, I can just have it removed. Yes, case lines will keep a timeline basically of when that happens. But I think from an aspect of removal, I think we can tighten that up. I must also add that the bigger issue for me currently is I don't have a better word than dignity in order to express this. It's dignity for a person. Consider a person now being in court whilst on a taxi and going to another place. Those issues are actually not specific to South Africa. In Canada, during COVID, in fact, a man was literally on a pay phone, like a telecom phone, speaking in court, and he's fighting literally for his house. He's sobbing on the phone, and one can hear the cars passing, people passing, etc. So that aspect of access is tempered by the dignity aspect that every person has, which, truth must be told, the decorum of a court does add to the dignity that a litigant feels, basically. So those are some of the issues that I'm picking. Thanks a lot.
Thanks a lot for that, Jazz. It was nagging me. Yes, I don't know if there's anybody else who wants to share their experience on that. All right.
So, colleagues, we have a question in the chat box from Clarity Klabano, and then we're going to move on to our closing comments. And she says that I am a law graduate and currently actively applying for candidate attorney positions. So good luck to you there, Clarity, on your journey to finding articles. It seems to me that most of my peers use ChatGPT to write their applications. My question then is, what is the opinion of law firms, law schools, organizations, etc., concerning the use of ChatGPT by applicants when writing their letters of motivation and or cover letters? Is it not detrimental to the application of the candidate as a whole when it's discovered that the applicant has had their cover letter or personal statement projected for them by an AI tool? Thank you. So
that's a fantastic question.
That's a good question. But I think, how funny is it that if you're struggling to write your own personal motivation letter, and you're using AI, then I'm a little bit worried about perhaps your personality.
Yes,
and
the ethics.
Anyone who's used it, spell checking and perhaps using AI to generate something that is deeply personal is obviously not very advisable. Advocate Karine, I see your video is on.
Yes, again, a very interesting question. Obviously, it would go against you if it was what I would think. Not that I work at a law firm, but I would think it would definitely count against you if you use AI for a motivational letter, because it is a very personal thing. And I think it's a mechanism to get to know a candidate on a personal level. Of course, their achievements, but also on a personal level. I think the question then comes up is, how do you detect if it's been written by ChatGPT, and yes, can it be picked up? Because I don't know how well these AI letters are. Perhaps if it's quite generic, then I know from when I worked at a law firm and I was in the HR committee, an uncreative motivational letter or something that doesn't add a bit of a personal element to yourself wouldn't be regarded as a good motivational letter. So I certainly think that it would count against you if discovered that you use that mechanism, but I don't know how well these AI letters are written. I haven't been faced with one in my own experience.
I suppose we'd all have to write our own and see if we feel it's a reflection of who we are. Well, that's a very, very interesting. So thank you for that question, Charity. Now we are going to wrap up. We are out of time, and we just want to thank all of our wonderful panelists for joining us today. We had a really great, robust discussion and some debates on AI and the changes and thoughts from the modern lawyer and how this digital landscape has really affected how we do things. And I'd like to thank my co-host, Advocate Kevin Malunga, for joining me in this webinar series. It's been a pleasure to host everyone who attended today. And I'd just like to share this lovely word of thanks from one of our attendees on LinkedIn, Raj Sharma. He says, I found the webinar to be extremely valuable and informative. I'm grateful for the opportunity to have attended. Thank you for sharing your knowledge and expertise with us. So thank you to our attendees. It's wonderful to have you on board. These webinars are recorded, so you can watch them at a later stage if you joined us late or have missed this webinar. And we will be bringing you this series from the Regenesis Law School every few weeks. And we hope that they give you something to think about and food for thought. Thank you once again to all my colleagues, and we hope that you have a wonderful week ahead.
Thank you. Bye.
Thank you. Goodbye.
Bye.
Recording stopped.